Good evening. I'm Sandy Thomson, the host of this show, which is called Life Ahead. But our real guest you're going to meet in just a moment if you haven't met him or seen him on our show already, and that is Bryan Nugen, an attorney. So think about that. If you have some legal questions, this would be your opportunity in the next half hour to give us a call here at 969-2720. We love it when you call and have questions for us. Now, our main topic tonight, we're going to be talking about estate planning and move on into some of the ramifications of that. Bryan has experienced a lot in his, how many years, Bryan?
Just over 30, believe it or not.
30 years.
It happens fast.
Well, he tells me he started practicing law at what, 10, 11,
10,
somewhere
12,
in there?
something like that.
Okay, Bryan, we love it when people call, and you welcome that. Yeah. And the reason we call our show Life Ahead, by the way, is because we try to give you each week information and education that will help you with some of the decisions you have to make in your life ahead. And that's what we're going to do again tonight as we start our show here. Let's start with some basic things, sure, Bryan, and then we'll get to some questions. Elder law. I indicated you were an elder law attorney. Right. What's the difference between an elder law attorney and any other attorney?
So there are different areas of the law in which attorneys oftentimes focus their practice. So my practice happens to be focused in elder law. So what people are probably used to hearing is estate planning. Estate planning is different than elder law. Estate planning is strictly planning for where your assets go when you pass away. Are you going through probate? You're going to try and avoid probate. Elder law does all of that, as well as protecting assets during your lifetime, making sure that as you age, and if you need assistance as you age, that you aren't running through all of your assets, spending all of your money, losing your home, etc. And then securing benefits to pay for that care. And those benefits could be in the nature of from the Veterans Administration, could be from Medicaid, etc. So typically, elder law is doing everything that an estate planning attorney does. Planning for where your funds go at the time that you pass, designating the individual to handle all of that for you, number one. And then number two is protecting assets during your lifetime. So you're working with folks that during their lifetime, protecting those assets and securing benefits for them. What's interesting is that sometimes folks get confused with elder law, thinking it's only for for clients that are 70, 80, 90 years of age. Actually, elder law attorneys oftentimes work with folks that are requiring guardianships or special needs children.
Like young couples.
You got it. Guardianships for folks that need a guardian, and that could be a younger person, or for a younger couple that may have a special needs child, or a special needs child is turning age 18, or we're securing funds for them, we're making sure that they're appropriately cared for, and that team around those special needs folks.
Well, when they turn 18, they need to get a guardianship and go before Judge Hout probably as well.
Here in Allen County, that's right.
Yeah.
Other counties, it would be different judges.
Okay.
Yep.
Okay, well, thank you for explaining that. And again, to emphasize, although we say elder law, it doesn't mean you have to be elder to be watching us here tonight or to even be talking to Bryan, because we're talking to all of you out there. Okay, we have a question already tonight, and this is from Juliet. And she says, my sibling is the executor of the estate. If I was to challenge the will in effect, how long will it take to stay in probate?
So, Juliet, you're asking if, so apparently there's something that's happening in that estate that's being probated at the court. So we have an estate that's in probate. Your brother's been appointed to be the personal representative. Sometimes people say executor, but in Indiana we say personal representative, and there's something in that estate that you don't like. So if you were to challenge that and you file an action, and you say, I want the will to be set aside, or I think that my brother isn't doing a good job as a personal representative, it's a legal action. And so how long would it take? It depends on the nature of that legal action. It depends upon the attorney that you're retaining and the discovery process that's going on. When the other side that's representing your brother, how they respond. Are we having depositions? Are we having a lengthy discovery process? How long is it going to take for you to get into the courtroom? So litigation inside of an estate or related to a estate can be just as long as any other type of litigation. There isn't a magic number. It wouldn't extend the estate by 1 month or 2 months or 6 months. I can tell you that I've been involved in state litigation matters that have taken years to resolve. I've been involved in litigation matters that the folks were able to come to a conclusion very quickly, and although it did extend the length of the estate, the probate process, it wasn't extensive and it wasn't horrible. But generally, litigation can take a very long time. Attorneys are very busy, the court's calendar is very congested, so that process can take some length of time. If in fact you can resolve your issues and resolve your concerns short of filing litigation, I would encourage you to do that. However, if it really is a situation that merits your filing an action, by all means do it. Obtain appropriate counsel for that, and by all means proceed and ask for those issues that you believe need to be corrected to be corrected.
Do you think that sometimes these types of things can, well, to use other legal situations, can be settled out of court so
Sure.
that we don't have to worry about the time frame?
I would say most cases, actually most litigation never goes to court. It actually does settle
really? Okay.
outside. Typically, courts will require, if there is litigation going on at some point in that litigation process, the courts will require a mediation. So they will order you to mediation, meaning that you have, Juliet, you would have one attorney, the person representing the estate would have another attorney, and typically then you would hire a third party, normally an attorney, to mediate between the two sides and attempt to come up with a resolution that will solve the case. And historically, I've mediated, and I always would like to say, if this is person A and this is person B, person A isn't going to get everything that they want, person B isn't going to get everything that they want, but how close can we get together so that you still can accept the resolution, understanding that if you don't resolve the matter, if you don't resolve it and you don't agree to it, it's going to cost more money, it's going to take more time. And frankly, it's very stressful to be in the litigation process. It's an emotional process, especially when it's tied to a loved one that's passed away and you're maybe inheriting from them. And it can be very emotional and very stressful. So to your point, Sandy, yes, if you can settle it outside of court, generally your dollars ahead and your stress ahead.
Yeah, for sure.
Yep.
And and since we're talking, as Bryan mentioned, maybe settling an estate for somebody that's passed, you get the whole family involved, and then you can create stressful situations or divisions among the family.
I think the sad part about litigation that goes on in estates is that that's the legacy.
Yes.
That's the legacy that's left from the family. That's what you're remembering. You're forgetting all those decades that you enjoyed someone and the relationship that you had, and unfortunately the legacy, that bad taste in your mouth that will last for the remainder of your life, is that litigation and how the person, you didn't believe that this person acted appropriately or that person acted appropriately. So by all means, if you can resolve it quickly and appropriately, I encourage you to do so. I think sometimes when folks pass away and you're inheriting, it's that last message from a loved one that they're going to be remembering you in a certain way, or they didn't remember you in a certain way. And so that too can create a legacy, sometimes very, very good, very positive, which is a majority of the time. Sometimes though, we have events that take place that may leave a sour taste in someone's mouth. And again, that's leaving a legacy and not necessarily a good legacy.
Right.
Yep.
Yeah, legacy isn't always positive.
No, it's not.
Okay, as an elder law attorney, what kind of situations or what do most of your clients come to you for?
I would say the clients that come in to see an elder law attorney, there are different stages in their life that I'm seeing that they typically are coming in. One, you mentioned earlier about a young couple. So we have a young couple with their first baby. They may not have garnered a lot of wealth yet, but they have this precious child. And they're recognizing, oh my gosh, if something happens to us, who's going to take care of that child?
Yeah.
So oftentimes folks come forward initially when they want to make sure that they have the appropriate guardian in place and things set up for that child if something negative happens with them. The next time that I see people is when some type of a medical event has happened, typically not a good medical event, and they're a little shook up and they're thinking, uh-oh, I better get some things in order. Somebody has a diagnosis that they weren't expecting, and so that's another time when I see folks. When people are getting close to retirement or just at retirement, Oftentimes when they're speaking with a financial advisors very frequently work with elder law attorneys and they're referring clients to them. So when they're with that financial advisor and they're getting their things together and ready for retirement, planning their that income stream that they're looking for in retirement or just at retirement, we oftentimes see clients then. The next phases that I would say that I see clients coming in and other elder law attorneys are seeing clients coming in is normally when you're in your 70s and you're seeing friends maybe suffering an illness, or you see a parent having an illness, or their cognition is declining and they're concerned, gosh, there's a lot of money going out to provide care for that person. We're seeing this sold or that sold, and that's not what they would have wanted. So oftentimes elder law attorneys work with folks during that time period. And I would say that the final time where we're seeing a lot of folks coming in to see elder law attorneys is when you have a nursing home stay, a memory care unit stay. You're paying for care in the home. Folks are writing that $10,000, $11,000, $12,000 check per month, and they're seeing their accounts dwindle. They're seeing their assets go down. So those are typically the high points of when I think most elder law attorneys are seeing clients come into them and looking for advice and work.
Okay, this is a question just spurred by what you just said. You were talking about writing that check each month for a nursing home or home health care. Mm-hmm. Obviously, if people are in their 70s, 80s, 90s, whatever, what they had planned for and anticipated as their retirement or money to last them the rest of their life may not be true anymore. How do you deal with that as an estate planner? How do they deal with it? It must be shocking when you hear numbers like that.
Yep. I would say as far as spending money, it's two things that I see in retirement. If you're healthy, normally I'm seeing folks spending less than they anticipated. You are living on your Social Security, your pension, and your distributions from your IRA, and oftentimes people aren't dipping into their savings. The shocker that you're referring to, Sandy, is when we have a medical situation.
Yeah.
And never anticipated it, never planned for it. I've never had a client that said to me, I just can't wait to go to memory care, I just can't wait to go to the nursing home. No, there is a time and place for both of those facilities, and there's nothing wrong with those facilities whatsoever. But people kind of, in the back of their mind, they're saying, that will never happen to me. But when it does happen, oftentimes that's when we see folks come in and saying, what can I do to stem the loss of my life savings? Yeah. What can I do to make sure I have enough money left to care for my spouse? When we have a husband and wife, for example, and the husband is needing care and the wife is writing those checks and she's getting nervous. Gosh, I'm healthy. I have a long life ahead of me and I'm seeing our reserves dwindle. That's making me very nervous.
Yeah.
So, of course, I see clients during those times.
Exactly. Hey, we have another question this time from Larry. Larry, thank you so much for watching us here on Life Ahead, and thank you for your question. He says, both my parents have a deceased. Both did not have a will. There is a house that has been in question.
So in regard to the house, if someone's passed away and they owned property, I would assume there's maybe more property than just the house itself. I don't know that. They could have accounts, etc. We're going to, if it's just the house, we may be able to transfer that. There's an affidavit process, actually, that's fairly straightforward to get the home transferred. If there is more than that asset, depending upon the amount of assets that the person has and the state in which they're living at the time that they pass, then you would have to open an estate, and within that estate then have the personal representative appointed, and then transfer that home from the name of the deceased to the individual that's receiving that. So if your parents didn't have a will, Larry, there's something called intestate succession that controls who gets that property. So there's a statute in every state that indicates if somebody dies and they didn't do that planning in advance, this is who gets that property. And we take a look at, did the parents that passed, did they have parents that were still living? Do they have children that are living? Do they have a child that maybe has passed and has and had children? So you've got grandchildren that are involved. So you look at that statute, and it spells out exactly where that real estate goes if your parents didn't have a will.
Let's say that Larry had siblings, and there's this house that has to be.
So all the siblings are treated the same.
Oh, okay.
So if there are five children of the deceased, they're all going to inherit the same. If if there's one child receives it all. So it's completely dependent upon how many children there were, who gets that at the time that the person passes. And we strictly look at the statute, and that spells it out.
I'm curious. You said the statute in the state that says who gets what,
Yep.
if there's no will. Is that different for every state? And who decides that?
Well, the legislature in the state decides that. Yeah. So there's a law that's passed, and that law indicates who gets that money when an individual passes. I would say generally, yes, it is different in every state. I don't know that it would be radically different in every state, but yes, each state's statute regarding intestate succession is different.
Okay, all right, that's good to know. Thank you, Larry, again for watching us here on.
Appreciate it.
Okay, thank you, and for helping Larry out there.
Hope I did.
It gets complicated, and you don't know what to do unless you're in that situation.
Yeah, I think too that sometimes people try to resolve issues on their own, and sometimes it's fully appropriate. If you're insecure about what you're doing or how to transfer those assets, I would encourage you to seek counsel. It doesn't mean that you end up having to use the attorney to do that, but you might just make sure you're on the right path, because that's an issue, especially with real estate, right? You can't just sign a deed because you want to sign a deed or you were the child. There's an actual process that we need to go through for that.
I love this question.
Great. What is it?
Love this question. I hope you're all in this situation. This is from John. Thank you, John, for watching and for calling in with a question. John said, I gifted my children a large sum of money, but I am living longer than expected. How to protect the money that I have?
Yep. So
if everybody lives longer than they expect, that's great.
That's fantastic. So I think the question that John is asking is, if I had made a gift to my children, and at some point I have medical concerns, I need help in the home, I need to move to an assisted living facility, I need to move to a nursing home or a memory care unit, and I've made that gift, how do I pay for that? Well, it's all time sensitive. So this is for Indiana, if you had given money away within 5 years, and then you need that care, there's a penalty that's imposed by Medicaid. And so for every X amount of dollars that you've given away, it creates a time period that's a penalty period. And the penalty means that somebody else other than Medicaid will have to pay for your care, will have to pay for your stay.
Yeah.
So if you intentionally made a gift, and you've given money away, obviously that was intentional, and you didn't get anything in return, Medicaid says, you gave money away, you didn't get anything in return. We assume that you gave that away to bring your estate down so that the state Medicaid will have to pay for your care. So they penalize you. So generally between $7,600, $7,700, for every $7,600, $7,700 that you've given away, there's 1 month of care that Medicaid will not pay for.
Oh,
so
really?
If you've given away, this is very rough. If you've given away $20,000, $21,000, there's 3 months of care that you're going to need to have paid for somehow. So if that cost of care is $10,000 a month, $11,000 a month, it will have cost you the gift that you made, plus that $10,000, $11,000, $12,000 per month of your care. So gifting as a means of reducing your estate so that you can go on Medicaid, that may be an element of that, but I would be very, very cautious about doing that without very good advice and how to do that effectively without creating a penalty for yourself. So how do you pay for that care? Well, you can ask for the children to give the money back to you that you had gifted. That's called curing the gift. You cure that gift, and then you appropriately plan for protecting that money, typically by seeing an elder law attorney, but you're going to plan to protect that money, and once that's handled, then Medicaid could pay for your care. If you really cannot receive the money back from your children, they can't afford to pay you back, then you're going to need to find out a different way to pay for your care. Gifting is not a way in and of itself to protect your money from long-term care stay costs, from memory care unit stay costs. You have to be very, very cautious with that.
Yeah, and I think it's important that you mentioned people should get some good advice, because I hear that a lot on this show, no matter what our topic is. When we get into estate planning, a lot of people get advice from neighbors, friends,
They'll read something on the internet. I will. Just recently, I came across that. I had someone that had read something on the internet, and
what? The internet's not always true.
Well, we have to. So there is good information out there.
I know.
But
I know.
understand how many different states there are. Every state has different rules and regulations.
Yeah.
When was it written? Medicaid regulations can change over time. So in what year was it written? Who wrote it?
Yeah.
Who was it written for? In what state was it written? So be very cautious about what you're reading. You can get yourself in trouble.
Right.
Sometimes people are well-intentioned and they're posting things online about this is what we did to protect assets. This is how we got mom on Medicaid. It's different if you're a single person. It's different if you're married.
Yeah.
So be very cautious about reading those things and not getting really quality counsel.
Good advice, for
Yep.
sure. Okay, now when people come to you for advice, for elder law advice, what are some of the first things they need to do or bring to you, provide to you?
So, great question. I like to have as much information about the individual's assets as they have. I normally will say to them, it's not to be nosy. What it does is it gives the attorney that you're speaking with information so that they know how it is that they can best help you. For example, a Roth IRA versus a traditional IRA may be treated differently. A brokerage account versus an annuity may be treated differently. So when you're speaking in generalities, it's not helping the attorney that you're working with to really be able to give you excellent advice. So I think the first thing to do is to make sure you generally know what assets you have: life insurance policies, checking accounts, savings accounts, brokerage accounts, or and the amount that you have, the number of zeros that you have is irrelevant. You just need to be straightforward, let the attorney know what you have, what things you're trying to protect, what things you're working with, how you want to pass those things when you die. So think of conceptually, what things do I want to protect? Where do I want those things to go when I pass away? Then I think also you need to be prepared to answer the question, who's going to help you if your health declines? Who's going to help you if your cognition declines? That information should also be considered by you before coming in to see an elder law attorney.
Okay, good tips there.
Thank
James has called in and he said, is there an age requirement to be a power of attorney for an estate or a will? Good question.
Yeah.
Is it the same for every state? See, I'm worried about all these states, I guess.
Well, the PBS goes in different states,
That's
so
right.
I always
That's
am
right.
sensitive when I'm answering because we've got Indiana, Michigan, Ohio, probably all oversee the broadcast. James, power of attorney is a document that is separate and apart from one's will. So if you're appointing someone, you're actually not appointing them to be a power of attorney, you're appointing them to be something called an attorney in fact. And the power of attorney is the document which appoints them as the attorney in fact.
Okay.
So what's the age? 18. So you have to be competent, you have to be age 18. Next, for your estate, the personal representative that you're appointing. So in your estate, you appoint a personal representative, not an attorney in fact. Again, they need to be 18 years of age, be competent. So hopefully that's answering your question. So you would not want a minor to be serving in that capacity. You need someone that's age of majority, 18 or older, and to be competent at the time.
Is that the same age then for guardianships? You talked earlier about
To be the guardian?
appointing,
But for,
guardianships.
depending, now, if you really were an orphan, right, and you had no family, and you didn't have anyone that was able to provide care for you, it is true in that situation you would require a guardian. However, when you turn 18, so at midnight, when you go from age 17 to age 18, and you are incompetent, we want to have a guardian in place that can make decisions in relationship to you, your person, and also make decisions in relationship to your finances, your money. So yes, at 18, when the person reaches the age of 18, that's when they may need a guardian if they have, if they've been declared to be incompetent, which could be for any number of reasons.
Yeah, got it.
Yeah.
Okay. 1 minute, that's all I have,
Okay.
Bryan. But I'd like you to share in 1 minute the most important thing people need to know about estate planning, pre-planning.
Sure. Pre-planning. Well, first, I'm going to say, James, to your point about the power of attorney, in fact, everybody needs a power of attorney. Everybody needs a healthcare representative designation.
Sure.
Everybody needs a HIPAA waiver form. So I'm a student going off to college for the first time. I encourage folks to have those in place. Those are as important as a will, trust. They really are essential. because with the properly prepared power of attorney, that individual that you've appointed can handle your estate planning for you if need be.
Oh, okay. And you said even going off to college.
Of course, you're 18. So let's say you're not married, you're a single person. Even if you were married and you were young, who's going to make those decisions for you? Yeah. If you have a car accident and we have a situation of incompetency, I have to go to court and open a guardianship if I don't have the POA in place.
Boy, there's just so much to remember and so much to do. Bryan, thank you, as
Thank you,
always,
Sandy.
for sharing information and education on
My
Life
pleasure.
Ahead here on PBS Fort Wayne. And, of course, we'll be back next Wednesday night right here at 7:30 with more information to share with you. Bryan will be back 2025.
That's right.
Meanwhile, those of you that have been watching, thank you for that, and have great holidays as they're coming up soon.
The preceding program on PBS Fort Wayne was made possible in part by
Nugen Law, specializing in estate planning and elder care law, emphasizing independence and quality of life. Serving Indiana, Ohio, Michigan, and Florida. More information at nugenlaw.com.